Welcome to Trust Us, Estate Planning Wisdom, the podcast where we unravel the complexities of estates and trusts to empower you with the knowledge needed for effective estate planning.
This podcast is hosted by seasoned estates and trust attorneys, Danielle Friedman, Fineburg, and Charles Max McCauley.
This podcast is your guide to the intricate landscapes of estate planning, including wills, trusts, and probate.
Thank you for joining us, and we hope you find the discussion informative. But remember, when it comes to legal matters, always consult with a qualified attorney regarding your specific case.
Welcome, everyone, to Trust Us. We're here this afternoon, Danielle Friedman, Max McCauley, and myself, Fineburg. We wanted to talk to you today about the rules of intestacy. What is intestacy all about, Danielle?
So intestacy generally means when somebody dies without a will, and depending on what state they were a resident of when they died, that state's law controls what happens to their property when they die.
So I don't understand. So you're telling me that you're going to have to trust the government to decide where your estate goes?
That's exactly right. So if you die without a will, something has to happen to your property, and the laws of each state dictate where that property goes. And a lot of people make assumptions about what their state's law says as far as where their property is going to go. And you would be surprised to learn that oftentimes the law is not what you would assume it would be. For example, clients often come to me and say, well, I don't need a will. I'm married. Everything's just going to pass to my surviving spouse. And while that may be true for assets that you own jointly with your spouse, because oftentimes when property is owned jointly, it passes to the surviving joint owner. For any property that is in your own name that doesn't pass by beneficiary designation, because that's a whole other type of rule. Let's say you just have real estate in your own name. It's going to pass pursuant to your state's intestacy statute when you die if you don't have a will.
Well, let me give you the standard situation. Client walks in, he's married, he has 2 kids, a 6-year-old, a 10-year-old, and his parents are still alive. What happens to his estate? Because it sounds like you're telling me, you're telling our audience that his estate will not pass to his wife.
So she's going to get something, but she's
This is
not.
Pennsylvania you're talking
Yeah. So in Pennsylvania, which is primarily where I practice, I also practice in New Jersey, but we'll talk about Pennsylvania because it is not the case that everything would pass to his wife. So if he is married and the children are also the children of his spouse, then his wife is going to get the first $30,000 of his estate plus 1/2 of the balance. And then the other half is going to pass to his kids. And his kids, in the example you gave, are minors and they can't inherit property. And so some clients will say, well, it's fine. Their mom will handle it for them. But that's not the case either. Their mom is not allowed to handle the property that goes to the children. They have to go to court and get court-appointed guardians. It's called guardians of the children's estate. And that is the person who's able to legally take title to the property that they're going to inherit. So it creates this whole waterfall of issues and unintended consequences when you have someone who assumes that everything is going to pass to their spouse or another beneficiary under state law, when in reality, state law often defies logic and says something completely different.
And I would like to add something that we said previously, and that is this outcome is different in every state. I practice in Delaware. So you're going to get a different outcome, however slight that might be, in every state. And it's going to depend on what state you lived in when you died without a will.
So in the example I gave, I had a married couple and I had 2 minor children. And you just explained the fact they're going to have guardians appointed. That's a very expensive process. It'd be a heck of a lot cheaper for the client to just set up a will.
Sure, absolutely. And on top of all of that, if something were to happen to the client and his wife at the same time, it's possible that then everything would pass to the kids and then they're minors. And not only do you need to have guardians of their estate appointed, you would also have to have guardians of what the state calls their person appointed, someone who's able to make legal decisions for them. And you have to go to court to do that. Normally, parents in their wills will say who they want to serve as guardian. Here, it's a free for all. It could be grandparents from one side of the family versus grandparents from the other side of the family, or any number of different individuals who want to serve as the legal guardians of these minor children. So you avoid a lot of disputes and infighting and unnecessary court involvement when you have a will.
So you're going to have two sets of grandparents who want to be the guardians of their grandchildren in that situation. But the client could have had a will and could have said who they prefer.
Yes. And so no matter what, when you have guardians of minors appointed, you do have to go to court. But when you have parents stating what their preference is in their documents, the court gives great weight to the parent's preference. And unless there is some other overarching reason why those individuals that the parents named in their documents should not serve as guardian, the court is going to give deference to what the parents put in their wills.
So let's use an example. Let's say there's an estate of $5 million and it goes into, let's say, 50% for each child, $2.5 million for each child into this guardian estate. How long does it stay in the guardianship estate for the children?
Well, that's the other problem. It only stays in until the children reach the age of majority, which again, depending on the state you're in, sometimes it's age 18, sometimes it's age 21, but still relatively young. And then you have an 18-year-old or a 21-year-old having unfettered access to $2.5 million, which we all know is not going to last very long in the hands of a teenager or a young adult. And that, again, could have been avoided if parents had a will, had set up trusts for the kids that would have received that $2.5 million in trust for the benefit of their children. And someone with more financial responsibility could oversee that money for the benefit of the children rather than $2.5 million passing outright to a child.
Sounds like a series of complete disasters. We often hear about people who sit down and say to their brother or their sister, well, I want you to be the guardian of my children because I think you're best fit for that. Does that count?
No, nothing that you say verbally, unless you commit it in writing in some way, whether it's in a will or other document that typically has to be witnessed and notarized. Your conversations with your preferred guardian are not going to bear any weight in court, because anybody could go and say, hey, the decedent told me he wanted me to be guardian. And then another party could also say, no, he told me he wanted me to be guardian. And then you have this conflict that no court is going to give any weight to. The other thing that arises, and Max, maybe you could enlighten us, if you have a decedent who owned a business and dies without a will, what happens to that business interest?
Absolutely. So we have another example that we can provide and walk through, and that is a pair of siblings that owned a business, and the one brother had no will, and he assumes
Was he married?
he wasn't married, didn't have any children,
Wow.
and he assumed that his brother would inherit his half of the business. Incorrectly assumed that his brother would inherit his half of the business, when in reality, under Pennsylvania law, it would have passed to his mother. He did not know that. Now, this is where it's important to have a lawyer involved, because not only can we solve this problem with a will, It can also be solved with other legal corporate governance documents, such as a buy-sell agreement or an operating agreement, shareholders agreement, partnership agreement, and the like. But you do need the lawyers to work hand in hand with your estate plan, do not conflict, and that the outcome of the death is the decedent's preferred outcome. And in this case, that was for the brother to get the business and own the business, and not his mother. But he had no will, and until he consulted with a lawyer, and the lawyer pointed out the several ways where this issue could be solved in a very inexpensive fashion up front, as compared to what would happen if his half of the business had passed to his mother, and then his brother was left with buying that business from his mother if he
What
wanted it to continue.
what happens if he either doesn't have a mother, doesn't have any living parents, or the parents say they disclaim it, they say, I don't want it, but he's got 3 other siblings. So the 2 siblings are in the business and 2 siblings are not in the business. What happens to his 50% interest in the business with the sibling?
Well, I could say what would happen under Pennsylvania's intestacy law, which if you don't have children, you don't have a spouse, you're not survived by any parents, but you have a number of siblings, whatever your interest is going to go to those siblings equally. It doesn't matter that some are involved in the business and some are not involved in the business. Let's say you have 4 brothers and sisters, all 4 of them are going to share that interest. And then you have to deal with the siblings that are involved in the business, maybe buying out the ones that are not involved in the business, or getting into this negotiation between family members to try to resolve this issue, where again, it could have been avoided with the governing documents that Max mentions, or a will in the absence of those governing documents.
Well, what happens, Danielle, if he dies intestate and there's a buy-sell agreement with the sibling? How does the intestate laws interact with the buy-sell agreement?
So the buy-sell agreement is going to control, because any contractual agreement that you've made during life, which is essentially what a buy-sell agreement is going to control over the state's intestacy statute. So with respect to the business interest, not really anything else that the decedent owns, the buy-sell agreement is going to control, and the state's intestacy statute would cover everything else, like bank accounts and things of that nature. A contract is very convenient in this situation because you can carve out exactly what you want to happen to that property with your co-owners of the business. There are other types of assets contract would also control. For example, a beneficiary designation is a type of contract. So if someone has a retirement account or any other type of account that permits a beneficiary designation, and they die without a will, but they have a designated beneficiary on certain accounts, those designated beneficiaries are going to inherit that asset. It's just everything else that is just in the deceased name that isn't controlled by a contract or beneficiary designation or by operation of law. Let's say if there's joint ownership, everything else gets funneled into the intestate estate, and that's where the state's intestacy statute is going to control. The other interesting thing I've noticed in a multi-jurisdictional practice and in an area where we live, where we have clients who own property in New Jersey, in addition to Pennsylvania, or in other states in addition to Pennsylvania, is that if you die intestate, one state's intestacy law may control where the property is located versus where you lived when you died. So you could have a beach house in New Jersey that's controlled by New Jersey's intestacy law, and the rest of your estate, if you died a Pennsylvania resident, controlled by Pennsylvania's intestacy statute. So the unpredictability is massive, where you could have certainty and control if you have a proper estate plan.
Jumping back to the buy-sell agreement as well versus dying intestate. The buy-sell agreement can dictate the payment price and the payment terms. Whereas if you died without a will, the remaining business owners are left to negotiate the payment price and terms with the siblings that they're buying out. And so they might be faced with less favorable purchase price or less favorable terms that might saddle the business with debt that it can't afford, ultimately leading to its demise.
So in your example, Max, you're going to have two siblings who are in the business. When you have a business, one of the great benefits of having a business is to get a salary. So if one of the owners dies and the siblings who aren't in the business, they're not going to receive a salary, and they're going to be pretty demanding and checking on all the things that the surviving sibling does, including his salary, his benefits. How's that going to work out?
Whether or not profits are being distributed quarterly or annually, are enough profits being distributed to cover the tax payments that are due on those profits.
Sounds like a case for massive litigation.
Usually involves very expensive litigation that might last for years and destroy the family relationship.
So again, a will is a pretty cheap solution to all these problems.
Absolutely. The other benefit of having a will and having a experienced attorney prepare your estate plan is that they can also review any buy-sell agreements, shareholders agreements, and the like that may exist so that there's no conflict between your estate plan and the governing documents of the business. Even though, as we discussed, the governing documents of the business control, we don't want the will to say something contrary to what the governing documents say, because if under the governing documents, the sibling is inheriting the business, but under the will, everything is passing to a friend, we don't want a friend to say, well, I should get the business interest, even though they're wrong. Anybody can sue for anything, and you have this unnecessary conflict generated that, again, can be avoided if you have competent counsel who makes sure that everything is in order and everything is not conflicting with one another.
Another added benefit of having a will and an estate plan, it enables your attorneys and your tax preparer to engage in federal and state tax planning as well as debt tax planning in an effort to try to minimize the tax burden associated with your debt.
That's a great point, Max, because again, I'll bring it back to Pennsylvania. Pennsylvania is one of the few states in the country that has an inheritance tax. And in the example, Herb, you raised earlier, where you have someone dying who is married, who also has children, the way that their assets pass under Pennsylvania's intestacy laws will trigger inheritance tax. Whereas if they had a will leaving everything to their spouse, no tax is going to be due. But because the person is leaving inadvertently by virtue of the intestacy statute assets to their children and to their spouse, anything passing to the children is going to trigger Pennsylvania's inheritance tax at a rate of 4.5%. If siblings are inheriting under intestacy statutes in Pennsylvania, the tax rate is 12%. So by not having a will, even if you have the best intentions, you are unfortunately imposing inheritance taxes on your beneficiaries. And that's just at the state level. If you have assets passing to non-spousal beneficiaries at the federal level, you're going to have to use a portion of your federal estate tax exemption. If you have someone with an extremely large estate that is going to be subject to federal estate taxes, you may be triggering federal estate taxes because you have assets passing to non-exempt beneficiaries, and that tax rate is 40%. So it's really important to have competent counsel make sure that your estate plan mitigates death taxes as much as possible.
So potentially up to 52% death tax, 12% to Pennsylvania and 40% federal.
Yeah, siblings are inheriting, absolutely.
And when are those taxes due?
Generally within 9 months of death. So it triggers, in some cases, what we call a fire sale, where if there's a business involved, you might need to sell the business in order to generate the cash needed to pay death taxes.
So it sounds like anybody who's married better have a will or be in deep trouble with his family after he passes. His legacy
I would
will
say
be hard.
Even if you're not married, if they don't have children.
And the other one is, as Max is describing, is whether you're married or not married, this could end up in a huge disaster, huge litigation expenses. And then on top of it, the icing on the cake is death taxes.
unnecessary income and death taxes. Yes.
As I tell all my clients, everybody needs an estate plan. It doesn't matter truly how much property you have, because none of us want the government making the decisions about where your property passes when you die, because oftentimes it is not where you would have selected your property to go when you die.
And nobody wants to unnecessarily pay extra federal income tax, state income tax, or death tax.
One of the things that I see people confused about is some people get a will and say, that's my estate plan. But I find that that's not necessarily an estate plan. It's just a stopgap document that doesn't take into account all the issues that we just discussed here.
Yeah, if you have your will, which is very simple, you go online, you get a 2-page will that says everything goes to my spouse. And if my spouse is not alive, everything goes to my kids. It's not an estate plan because you haven't taken into consideration how much your kids might get, if they're going to be minors when they inherit, whether you want your kids to inherit property outright or whether it should pass to them in trust. And frankly, same thing applies to your spouse. If you're a young person, and I'm just using young people as an example, but this could apply to anyone at any age, and you leave everything to your spouse, and then your spouse gets remarried, and in their will, they leave everything to their new spouse, and then they die, nothing is really passing to your kids, which is probably where you really wanted your property to go. And all of that, as we've discussed in other episodes, can be addressed, and those problems can be eliminated through the use of trusts in your estate plan. But in order to know to do that, we don't expect your clients to know to do that. That's where an estate planning attorney comes in and provides those recommendations. And then the clients have an aha moment and say, yes, that's what I need. That's what I want.
So back to the siblings that own the business. Hypothetically, if they had bought the business from their parents and they then own the business 50-50, the sibling without the will and without a wife and without children, his parents would inherit his half. The remaining surviving business owner would then again have to buy the business, 50% of the business, from his parents.
Oh, what a disaster that is.
Buy it twice in the course of a few years, potentially.
Well, we could find a large number of scenarios where people are just simply shocked about what's happened. You don't hear about it on the street because nobody talks about the problems they've had. But in our business, we see all these things happen and play on every day, and we scratch our head as to why people don't plan, but would rather have their family go through the time and expense of dealing with their death.
But in my experience in closely held family businesses like that, it usually leads to family disharmony among the beneficiaries when somebody dies without a will, because then whether it's the siblings, the children, the spouse, can't agree on who should get what and what amounts and what percentage.
And sometimes that's the most valuable aspect to all of this, not so much the business or the money that anyone's going to receive, but just family dynamics and the preservation of relationships. Again, having a will, having a proper estate plan, having trusts in place, preserve all of that on top of course, giving you control and certainty about where your property goes. You're going to be sure that your family isn't fighting over what happens when you die.
I'll ask to you as well, but in my experience, when you die without a will, the legal fees expended as a result of that decision are usually 100 or 1,000 times the legal fees that would have been spent preparing a simple will and estate plan. Is that your experience as well?
It's oftentimes more expensive, no doubt. And not only more expensive, more time consuming, things move slower through the courts. You have to have more court involvement. If you have someone dying without a will, it just becomes this costly slog that could have been avoided. And I understand for some people, thinking about their death and thinking about where their property is going to go isn't a conversation that they want to have. But sometimes reality has to set in, and you have to know that even if you avoid this conversation, state law is going to kick in. So it's better to make those decisions on your own rather than
Trust the government to make the decision.
Yeah, absolutely.
Well, great. Very interesting topic for our listeners.
Thanks, guys.
Thanks.